Imagine this. You're inside a trailer home in Washington County, Maine. A woman's ex-boyfriend shows up, uninvited. Things are tense, they're arguing, and there's a rifle involved, a small caliber one. And then, suddenly, there's this loud pop, like a firecracker. The man collapses. He looks up at her and says, "It was an accident. It wasn't supposed to happen." He's bleeding badly from a gunshot wound to the abdomen. Now just freeze that moment. This is where everything changes. Morally, you know what's supposed to happen next. She calls 911. She applies pressure, something. But that is not what happened here. She doesn't check for a pulse. She doesn't even look for blood. She just turns around, walks out, and tells a friend he's just pretending to shoot himself. By the time help finally arrives, he's gone. And here's the part that makes this so legally fascinating and so morally devastating. A doctor later testified that if he'd gotten to the hospital just 5 to 10 minutes earlier, he could have been saved. So this brings us right to the edge of negligence law. Your conscience tells you one thing. But what we're asking today is, can you legally just stand by, watch someone die, and simply walk away?
It's a brutal question, and it's one that gets at this huge gap between what feels right and what is actually required by law. So today we're doing a deep dive into the doctrine of nonfeasance, specifically the no duty to rescue rule. It's a really harsh corner of the common law. We're going to use the case estate of Joshua S. Cilley v. Jennifer Lane to understand why courts are so hesitant, so terrified, really, of trying to legislate morality.
I think most people would just assume, if you can save a life with zero risk to yourself, literally just making a phone call, you have to do it.
Yeah.
The law must demand that. But you're saying that's not the default.
Not at all. Far from it, actually. The baseline in American common law is, well, it's pretty cold. It prizes individual liberty over any kind of mandatory aid. The general rule is that a person owes no duty to rescue or aid someone who is in peril.
No duty at all.
None. And we have to be really precise about this. You could see someone is dying. You could know you're the only person who can help. You could realize that helping would cost you nothing. And still, the law says you can do absolutely nothing. That realization alone doesn't create a legal obligation.
That feels so wrong. So counterintuitive.
Mm-hmm.
If I see a toddler face down in a puddle, I can't just walk by.
Morally, no, of course not, but legally. Unless you're the one who put the toddler in the puddle, or unless that's your toddler, the common law generally says, yes, you can. And that's the key distinction here. Misfeasance, that's active negligence, doing something wrong, versus nonfeasance, which is passive, just doing nothing. Courts hate punishing people for doing nothing.
Okay, but there have to be exceptions. It can't be a free-for-all.
Yeah.
When does the law finally step in and say, okay, you must act?
You're right. It's not complete anarchy. There are very specific triggers that switch from no duty to an affirmative duty. The two big ones for our case today are creation of danger and special relationships.
Okay, explain those.
Creation of danger is simple. You broke it, you buy it. If your conduct, even if it wasn't negligent, created the risk, you now have a duty to help. Second, special relationships. And this isn't just, being friends. This is a legal term. We're talking about relationships where one person has control over or custody of another. Think parent and child, or a common carrier and its passenger. The dependency creates the duty.
All right, so those are the ground rules. No duty to help unless you cause the mess or you're in one of those specific protector roles. So let's take that framework and apply it to estate of Cilley v. Lane. Let's analyze the case. First, what are the legally dispositive facts?
Okay, so focusing only on what mattered to the court. Fact 1. Lane and Cilley were ex-partners. She had ended the relationship. Fact 2. Cilley arrived at her trailer, refused to leave. An altercation occurred. A rifle was involved. And this is a critical fact. It was undisputed that Cilley himself was handling the rifle when it discharged. Lane was actually leaving the room. She hears the pop, sees him fall, and hears him say it was an accident. And then, the key in action. She doesn't check on him, doesn't call 911, and tells her friends he was pretending. And finally, the causation fact. Medical testimony established that he could have been saved if help had arrived just 5 to 10 minutes sooner.
And what was the core legal issue that came out of all that?
The legal question was this. Did Jennifer Lane owe Joshua Cilley a duty of care to seek emergency assistance, given that he was a guest in her home and she witnessed his injury?
What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Absolutely. The court applied the general rule of nonfeasance. The rule is, absent a special relationship between the parties or conduct by the defendant that created the danger, a person owes no duty to summon aid for an injured person. So this gives us 2, maybe 3 elements to test. First, did the defendant's conduct create the danger? That's element 1. Second, did a recognized special relationship exist? That's element too. And third, the plaintiff argued for a new duty. Basically, should there be a duty just based on being a homeowner or an eyewitness? We can call that the proposed element 3.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, creation of the danger?
Okay, so a mini IRX for this element. The sub-issue was, did Lane's conduct create the dangerous situation? The court looked at the facts. Cilley brought the final dangerous instrument into play, the gun, and he was the one holding it. He shot himself, even if it was an accident. So the court's application was that Lane's actions, like arguing with him or being in the trailer, weren't the direct cause of the peril. The peril was self-inflicted. Conclusion on this element, the creation of danger exception did not apply.
Understood. So she didn't break it in a legal sense. Now, what about the second element, the special relationship?
Right. Another mini IRAC. The sub-issue here is whether ex-girlfriend or social host counts as a legally recognized special relationship. The rule for these relationships is that they involve some level of custody or control, a parent over a child, an innkeeper over a guest. Applying that here, the court found no precedent, no history of treating romantic partners or social hosts as custodians. Lane had no legal control over Cilley, an adult man, so the conclusion for this element was clear. No traditional special relationship existed.
Okay, so that brings us to the most critical part of the appeal. The estate was arguing for a new duty. How did the court analyze that proposed duty to seek emergency assistance, just based on witnessing the injury in her home?
This is where the court really had to wrestle with public policy. The sub-issue was, should Maine's common law now recognize a new duty for a homeowner or an eyewitness to call 911? The court's analysis looked at factors like the hand of history and social ideas. They had to ask what the consequences would be. They distinguished witnessing an injury from the established relationships because it lacks one key ingredient: control. A witness has no control over the injured party. But the biggest factor was a policy argument. The court cited a deep fear of creating boundless liability.
Boundless liability.
Right.
It sounds like the classic slippery slope argument.
It's the ultimate slippery slope. If a duty exists for Lane just because she was there, where does it end? Does it apply to a stranger on the street who sees a car crash? To a diner in a restaurant who sees someone choke? The court feared they couldn't fix any limit to liability if they opened the store, so their conclusion was firm. They refused to create this new duty.
And after analyzing all the elements, what was the court's final conclusion on the entire case?
The final holding was that the summary judgment for Lane was affirmed. Because Lane did not create the danger and had no special relationship with Cilley, she had no legal duty to rescue him or call for help. And this is the harsh part. This was true regardless of how easily she could have done so, or the fact that her inaction contributed to his death.
I really wanted to drive this home for our listeners. It's such an alien concept. Can you give us a visceral hypothetical to show just how far this no-duty rule can go?
Sure. Let's use the mere bystander hypothetical, which is what the court was afraid of. Imagine you're walking down the street, you see a stranger ahead of you get struck by, let's say, an act of God, a bolt of lightning. Or they just trip and crack their skull on the pavement. They're unconscious, bleeding out. You are the only person there. You have a phone in your pocket.
Easy to call for help.
Trivial, but instead you think, I'm late for coffee, and you step right over their body and keep walking. They die because help didn't come in time. Under this ruling, civilly, you are liable for absolutely nothing. Zero.
Wow. That's chilling. You can literally step over a dying person and face no legal consequences.
Yes, because you didn't create the danger, the lightning did,
Yeah.
and you have no special relationship, therefore no duty. The court's fear is that if they hold Lane liable, they must logically hold you liable too, and they don't want to go there. They believe that if society wants to create that duty, the legislature has to do it with a specific statute.
You mentioned statutes earlier for things like snowmobiles and hunting. Can you expand on that?
Yes, and it's a crucial point. The court itself noted that the legislature knows how to create these duties. In Maine, there are specific statutes that say if you're in a hunting accident or a car crash, you must render aid. The court basically said, look, the legislature has acted in these very specific high-risk situations. It has not acted for the general situation of being an eyewitness. So that legislative silence is powerful. It tells the court to stick to the old, narrow, common law rule.
So it's a conflict between specific laws for dangerous activities and the general default rule for just being a person in the world.
Exactly, and that's the tragic outcome of this case. The court isn't saying Lane's actions were good or moral. They're just saying they weren't legally actionable. She didn't kill him. She just failed to save him, and in the eyes of the law, that's a world of difference.
So for anyone listening, maybe a law student trying to prepare for an exam,
Yeah.
how do you organize this? Is there a clean framework for spotting this issue?
Absolutely. You can use a step-by-step diagnostic checklist. If you see a potential nonfeasance issue, here's your flowchart. Step 1. Classification. Ask yourself, is the defendant being accused of misfeasance doing something wrong or nonfeasance failing to act? If it's a failure to act, proceed.
Okay, step 1, classify the inaction.
Step 2. Apply the no duty presumption. Your default starting position should always be, there is no duty to rescue.
Got it. Start at 0.
Step 3. Check exception. A. Creation of risk. Did the defendant's own conduct, however innocent, cause the peril? If yes, a duty exists. If no, move on. Step 4. Check exception B. Special relationship. Does the relationship fit a strict custodial category? Parent-child, common carrier, innkeeper. Remember, friend, social host, or witness is not enough.
What's the last check?
Step 5. Check exception C. Statutory mandate. Is there a specific law on the books for hunting, for car accidents, for something else that forces a duty to act in this exact situation?
And if you run through all those steps and you come up with no for every single one,
Then step 6 is your conclusion. No duty, and therefore no liability. It doesn't matter how morally troubling the facts are. If none of those exceptions apply, the defendant walks away, just like Jennifer Lane did.
that is a tough pill to swallow. It just makes it so clear that the law isn't a system of morality. It's a system of rules designed to balance individual liberty against social responsibility. And sometimes that balance feels way off.
That's the core lesson of this entire deep dive. Cilley v. Lane shows you that the law fiercely protects your right to be a bystander, your right to do nothing. It draws a very hard, very bright line between what is morally outrageous and what is legally required.
The court will punish you for hurting people, but it won't punish you for failing to be a hero.
That's it, exactly.
A grim reminder that just because something is legal doesn't make it right. And maybe if you find yourself in a situation like that, the law isn't the book you should be consulting. That's it for this deep dive into a state of Cilley v. Lane. Thanks for listening.